Welcome to the Judicial Committee of the Privy Council, where today we're hearing two appeals from the Court of Appeal of Trinidad and Tobago, Crick against the Commissioner of Police and Philip against Kurt Brown. The appeals are being heard online because of the current pandemic. Both appeals concern the consequences of failure to comply with court orders. For that reason, the two appeals are being heard together. I'm Lord Lloyd Jones, and I'm sitting today with Lord Briggs, Lord Sales, Lord Hamblin, and Lord Leggett. The appellants, Judy and Nancy Crick, are represented by Mr. Colvin Blaze. The respondent is not taking part in that appeal. The appellant, Rupert Phillip, is represented by Mr. Navindra Kamnanam. The respondents in that appeal are represented by Mr. Rowan Pennington Benton. We will hear the appellant in the Crick appeal first. Mr. Blaze.
Good afternoon, my lords. That's for purpose of clarity. My matter is Crick versus Brown, my lord. I'm not Commissioner, not the Attorney General.
Right.
Yes. So, my lords, the matter that before you involves an appeal that was made to the Court of Appeal of Trinidad and Tobago, the particulars of which are listed at M26 of the bundle, my lord, which has the submissions of the appellant defendants. And at that, in my submission, a brief history of the actual matter is provided at M27. There was an order given in that particular matter, which was the appeal. The grounds of the appeal are listed at M29. The matter having been appealed, the appeal proceeded from the standpoint of filing of the record of appeal, application for stay of execution, grant of the stay of execution, and then directions were given with respect to the issue of the filing of written submissions. There was no sanction attached to these directions that were given. The directions were not complied with. The matter came up on the 12th of April for hearing before the court, and the appeal was dismissed on the basis that submissions were not filed. It is this dismissal of the appeal that is before the court today. The issues that have been identified are more or less issues listed at M22, in which it's been alleged that the Court of Appeal erred in dismissing the appellant's case. One, without considering CPR 6413 and the court's inherent jurisdiction. Two, without providing or having recourse to an alternative resolution, such as extension of time for the filing of these submissions. And three, without at least entertaining the prospects of oral submissions. Now, for purposes of clarity, the two main areas for which I will be structuring the argument. First one will be on the issue of the lack of sanctions and how, in our respectful view, the matter ought to be dealt with. And two, it deals with the issue of the Court of Appeal's obligation to comply or to give effect to the overriding objectives, and whether or not the court did in fact do that relative to the decision made to strike out the court of the particular appeal.
Mr. Blaze, are you aware that the permission that was actually given in this case to appeal to the Privy Council was confined to the question as to whether the Court of Appeal complied with Rule 26(6)?
No, my lord. The 26-6, I believe, probably the other appeal, my lord. We are very clear in our notice of appeal in making reference to 6413 as well. We did not confine our argument to 26-6.
Well, we'll hear you on the grounds de bene, Mr. Blaze.
Guided, my lord. Guided, my lord. Now, my lord, with respect to the order of the court was given without sanctions. And I would want to make reference to two things. One, in the rules as they existed at the time, for the most part, there's a requirement with respect to the filing of skeleton arguments. There's no requirements under the rule per se at that time with respect to the issue of the filing of written submissions per se. The Rules Committee of Trinidad and Tobago amended that in November of 2018. And I would have provided the relevant legal notice, my lord, to legal notice 159, 19th of November 2018, in which part 6411 and part 6413, they were both amended to remove the word skeleton arguments and insert the word written submission. We are submitting that both are not one and the same, and the court, in giving an order requiring written submission, one, it would not have had any legislative recourse under part any of the CPR. So therefore, it had to be treated as an order given by the court and therefore subject to 26-6. And 26-6 makes it mandatory that any order of the court (26-6-1) says where the court makes an order or gives direction, the court must, whenever practicable, also specify the consequence of failure to comply. So, my lord, if we also look at the authority of Karen James, Karen Matthews, sorry, my lord, which I would have provided to the court. And Karen Matthews.
Sorry, where do we find that?
It was an additional authority that would have been provided to the court, my lord. And it would have been the Attorney General versus Karen Matthews, Privy Council Appeal number 68 of 2010.
I'm afraid I don't have that at the moment.
Similar, but I would have sent it. Yes, Mr. Benton. Yeah.
Thank you. Sorry to interrupt, Mr. Blades. If it assists, and your lordships have got the electronic bundle in the Philip matters, we have Philip matter. We have the same case, so it's in the authorities bundle at tab 7, page 234 of the bundle.
234. Thank you, Mr. Benton. Yes.
Thank you very much, Mr. Benton.
Thank you for that.
So, my lord, at paragraphs 19 and 20 is what I would wish to refer to with respect to Karen Matthews. And paragraph 19, it says the board is conscious of the overriding objective and the court's obligation to give effect to it when it interprets the meaning of any rule. The jurisprudence developed by the Court of Appeal emphasizes the fact that the overriding objective of dealing with cases justly includes dealing with cases in a way which are proportionate and dealing with cases expeditiously. when we go to the last sentence in paragraph 19, it says, the board certainly has no wish to impede the court's commendable desire to encourage a new litigation culture to undermine the steps that it is taking to rid Trinidad and Tobago of the cancerous laissez-faire approach to civil litigation. At 20, the board then went on to say, nevertheless, if the language of the rules admits of only one interpretation, it must be given effect. Bearing that in mind, my lord, our submission is the rule relates or covers clearly the issue of what should take place when orders are given or directions of the courts are given. And it states at 2661 that where the court makes an order or gives direction, the court must, wherever practicable, also specify the consequences of failure to comply. Yes, my lord.
Yes, looking at this authority, it looks to be an authority specifically on the impact of Rule 13.3.
Yes, ma'am.
And the suggestion that Rule 13.3 could not be treated as overridden or bypassed by any implication of sanction. But we're not dealing with a case within Rule 13.3. Directions were set. Isn't it necessarily implicit when the court sets directions that whether one calls it a sanction or not, a party will be in mercy of the court if they fail to comply with the directions given, and that the governing principle that the court will apply in deciding whether to release them from compliance with the direction will be a question of fairness as between the parties.
Indeed, my lord, but what we are saying as well, the principle from Karen Matthews treats with the issue of a rule not being open to interpretation, but being clear, i.e. there is no implied sanction. And in this particular case, my lord, we are saying that the rule with respect to the issue of orders and directions, 26.1 is clear. 26.1 is not ambiguous. It says that the court must, where practicable, specify the consequences of failure to comply. Now, if we accept the fact that written submissions and skeleton arguments are not one and the same, we will have a situation where the issue of written submissions are not being dealt with by the rules at all. Therefore, it's just the subject matter of an order or direction of the court, in which 2661 makes it clear that there must be some direction given with respect to the failure to comply. And that is the basis upon which the Karen Matthews is being used as the authority, my lord.
But Mr. Blaze, isn't it the case that if directions of the court are to have any effect at all, it must be that a party is required to comply with them? They can't just decide whether to comply or not, depending on how they feel like it. And that if they don't comply with them, whether one calls it a sanction or not, they're going to be in mercy with the court, and the court will have to decide in those circumstances what the fair course of action is.
Yes, my lord. That is a particular position with respect to the court having the issue of its management powers, which is what Karen Matthews itself said. All right? Because Karen Matthews was dealing with the issue of the court, basically treating with an implied sanction. And what my lord is alluding to is the issue of an implied sanction, which the board in Karen Matthews has stated that if there's a rule that clearly states what should flow or how it should be dealt with, then that rule ought to be applied. And the court And the board was particularly careful to indicate that it did not want in any way to interfere with the Court of Appeal's ability or latitude to manage its affairs. But it says the issue of an implied sanction, if there's a rule that clearly states how the matter is supposed to be dealt with, then we have to be guided by the rule.
Yes, thank you.
Yes, my lord.
What do you say the directions sort of specify? Because the non-compliance could have consisted of being 1 day late, a week late, a month late, 6 months late, or simply not having complied by the date of the hearing. Does the rule have, does the directions order have to specify all those different consequences and possible results? Or does it simply have to say, and if you don't comply on time, you'll have to make an application for further time?
Molo, can you repeat the question? I wasn't clear on what my lord was asking.
Does the, I'm wondering what you say would have been the appropriate specification of sanction to put on the directions, bearing in mind that when the court gives the direction, it cannot know in advance how serious any non-compliance is going to be. Is it simply that the court should have said at the end of the directions order, and if you are late with any of these requirements, you will have to make an application, which may or may not be granted?
My lord, the short answer is yes, my lord. For a number of orders now, the court make what we call unless orders, so that they upfront identify that should there be non-compliance, then there will be a sanction, and therefore if that is the case, then everything else kicks in with respect to applications and relief on sanctions and all of the other rules that would apply, my lord. As in the case of real times and Renoir, which what we have already quoted as well, my lord.
Thank you.
Yes. Yes, my lord. So, my lord, again, we are treating with the issue of the written submissions and skeletal arguments not being one and the same. And again, we are pointing to the fact that it was only in 2018 changed and made part of the rules. And if my court, if my lord is not moved by that particular argument, and we accept that 6413 as it relates to skeleton arguments will also apply with respect to the issue of written submissions, then 6413 provides that if there is some form of transgression, then the court has the prerogative to issue a notice, a non-compliance notice. The next step, my lord, with respect to 6413, as it says, and this one is if we accept that written submissions and the issue of skeleton arguments are one and the same, it says any party to the appeal fails to serve, and this is 2113(1)(c), fails to serve a skeleton argument within the time limit specified by or under the relevant rule or any extension permitted by the court, then any other party to the appeal may apply for the notice of appeal or counter notice, as the case may be, to be struck out, or the court may, with or without an application by any party to the appeal, direct that notice be served on the appellant and on any respondent who has served the counter notice to show cause why the notice of appeal or counter notice should not be struck out. So, my lord, based on the directions given, it would have been open to the Court of Appeal as well to serve notice to show cause And again, my lord, this is important insofar as the court needs to take into consideration relevant factors in ensuring that the overriding objectives to deal with matters justly as provided by part 1 and 1.2, that those overriding objectives are met.
Yes, Mr. Blaze, there's a question from Lord Sales.
Yes, ma'am.
Yes, Mr. Blaze, I see Rule 64.13, but in your case, the Court of Appeal did not strike out the appeal. It seems to me that 64.13 is looking at some sort of procedure for striking out an appeal before an appeal is called on for the substantive hearing. But in your case, the appeal was called on for the substantive hearing. It's just that the court ruled that it would be unfair for your client to present oral submissions, having failed to give notice of what those submissions were going to be in writing. And therefore, there being no valid submissions in support of the appeal, dismiss the appeal. That's not striking out the appeal, that's dismissing the appeal on the merits.
No, my lord, that is not dismissing the appeal on the merits. My lord, and I will trivially assume when we look at the transcript from the Court of Appeal, no aspect of the merit of the appeal was dealt with at all. My lord, and I would want to get into that.
But forgive me, Mr. Blaze, that's because your client was not allowed, having failed to put in a skeleton argument saying in writing what their argument was going to be, was not allowed to start completely afresh with oral submissions in support of the appeal. Therefore, at the substantive hearing, there were no good submissions by your client presented to the court in support of the appeal, leading to the conclusion that the appeal was dismissed.
No, my lord, but the court did not take any submissions. It's not as though there was not an offer with respect to the issue of making those submissions. So to necessarily say that the court is hearing the matter and no submissions were made is not accurate, my lord. The court decided that it was not hearing the submissions. And with respect to 64.13, my lord, I'm saying that the Court of Appeal, and it would not have been on the morning of the hearing itself that the court itself would have been aware that no submissions was filed. The court would have been aware of that very early on, my lord, that no submissions were in fact filed, and therefore 64.13.1 also gave them the opportunity to be able to issue the notice of non-compliance.
Yes, thank you.
Of non-compliance, my lord. So on that particular ground, my lord, we are saying that the Court of Appeal have, with respect to an option, with respect to being aware that there were no submissions, then 64.13 gave them the option, with respect to dealing with the matter fairly, of issuing a notice to indicate why they said appeal ought not to be struck out. All right, and this particular 64.13 never did not say before the hearing or anything like that. It said that if it is not filed, then the next step is to issue that notice of non-compliance and give the party an opportunity to be able to put in to them, or to give to them reasons why it ought not to be struck out. And that is important, my lord, as it relates to the next point that I'm going to get into with respect to the obligation of the court to apply or to treat with the issue of the overriding objectives.
Before you move on, Mr. Blaze, can I just ask you about the wording of 64.13.1c? Time limits specified by or under the relevant rule. Is there any time limit specified by or under the relevant rule?
No, my lord, there's no, with respect to the relevant rule, no, my lord. This is the time limit imposed by the order of the court itself.
Yes. There was subsequently an amendment to the rules which introduced a time limit.
Subsequently, my lord, not at the time
Yes.
of this, my lord.
Thank you.
Yes, my lord. Yeah, so my lord, with respect to the issue now of the overriding objectives, I wish to refer to the case of Summer versus Fairclough Homes Limited. And my lord, if I may start first by making reference to paragraph 41.
Yes, what page is that, please? In your bundle?
My lord, it is hyperlinked. Page 40, my lord, and it is hyperlinked.
40.
Yes, my lord.
Yes. Thank you.
And on paragraph 41 of that case, it says the language of the CPR supports.
Can you just give us the electronic reference to the page itself, because it's not working here.
The electronic, my lord, is the All England Law Reports, volume 2012, volume 4.
The electronic bundle page reference for Summers and Fairclough Homes.
Page MS40. MS40, my lord.
No, that's the index page.
It's hyperlinked, my lord.
Yes, but the hyperlink's not working.
Oh, I see. My lord, I would have sent the actual copy of the case to the court as well.
I think I can point out that it appears to have been added to the set of bundles available for this hearing, but as a separate document. So it's not in the electronic bundle itself, but it should be in the list of bundles for this hearing as a separate document.
Oh, yeah.
Yes, it's a separate
Mr.
document.
Blaze, I have the electronic edition.
Yes.
Which paragraph did you want to refer to in the judgment?
So it starts, my lord, by paragraph 41, where it says the language of the CPR support.
Just so everybody knows, that's electronic 16 of that separate bundle.
Page 16 of the case, my lord.
Yes.
Yes, so paragraph 41, it says the language of the CPR supports the existence of a jurisdiction to strike a claim out for abuse of process, even where to do so would defeat a substantive claim. It further goes on to say, at the following sentence, there is nothing in the rule itself to qualify the power. It does not limit the time when an application for such an order must be made, nor does it restrict the circumstances in which it can be made. The only restriction is that contained in CPR 1.1 and 1.2, that the court must decide cases in accordance with the overriding objectives, which is to determine cases justly. The last sentence at paragraph 45, the board also noted that the power to strike out is not a power to punish, but to protect the court's process. And again, with respect to the issue of the rights, the right to fair and public hearing in the determination of the civil rights is enshrined with respect to the Constitution of Trinidad and Tobago, the case. submissions on the other side. Yeah. Constitution, my lord. So it makes reference to that. At the last sentence of 46, it said, however, the essence of the right of access must not be impaired. Any limitation must pursue a legitimate aim, and the means employed to achieve the aim must be proportionate. Again, my lord, at paragraph 49, the court acknowledges the court has a wide discretion as to how to exercise its case management powers. These include the power to strike out the whole or any part of the statement of case at whatever stage it is made, even if it's made at the end of the trial. At the end of that paragraph, it says, the draconian step of striking a claim out is always a last resort. A fortiori, where to do so would deprive the claimant of a substantive right to which the court had held he was entitled after a fair trial. It is very difficult indeed to think of circumstances in which such a conclusion would be proportionate, and that is with respect to the issue of the striking out. And again, my lord, I refer to paragraph 61, in which it states, the test in every case must be what is just and proportionate. It seems to us that it will only be in the very exceptional cases that it will be just and proportionate for the court to strike out an action after trial. And in conclusion, the board noted, although we have accepted the defendant's submission that the court has the power under the CPR and under its inherent jurisdiction to strike out a statement of case at any stage of the proceedings, we have concluded that that power should in principle only be exercised where it is just and proportionate to do so, which is likely to be only in very exceptional circumstances. So, my lord, when we look at, so my lord, what all of the rulings say is that the court in making its decision must be guided by the overriding objectives. So if we accept that, okay, you have the latitude to make those decisions, it is saying the only check on that is whether or not they have complied with the requirements of the overriding objectives. Well, when we look at, if you look at MS 68, my lord, the MS 68 details the transcript of the proceedings that led up to the dismissal. And when we look at the transcript in order to be able to come to a conclusion of to what the court take into consideration, I ask my lord to look at M70, paragraph 48, 49, and 50. Lines 48, 49, and 50, in which the court says, Mr. Blaze, we can't continue like this. We take on average about 5 years to complete an appeal, and this is not helping. We go on to page M71. This is becoming more and more pervasive. And if we continue to do this, we will be digging ourselves a hole out of which we could never climb. So this, my lord, implies that the court is taking into consideration not necessarily matters specific to this case, but it's taking into consideration matters outside of this case. And not, yes, my lord.
Does not your overriding objective also require that the court make sure that it allocates
my lord, you are breaking up and I'm not hearing.
Appropriate share of its resources to each case for the protection of other court users?
Lord Briggs, I'm afraid we can't hear you very clearly. It's breaking up.
I'm sorry. Can I try again? Doesn't overriding. Right, I'm going to have to leave and come back on the telephone, I fear.
Do you want to have another attempt, and then we'll see if it's necessary to interrupt the hearing?
Can I ask what I think Lord Briggs was asking, if that's easy, it might help, and if you
Yes,
can hear
please.
it, what it was. Mr. Blaze, I think Lord Briggs was intending to ask you whether it's right that your overriding objective expressly empowers the court to take account of not only fairness to the parties, but the administration of justice more generally.
Well, yes, it does, my lord, but it doesn't confine it only to that. And I'm saying when we look at the transcript, it is as though the only consideration for the most part that was taken by the court, or a significant part, dealt with the issue of external matters taking place, my lord. So, and is that reference to those external matters is what I'm referring to, my lord. Yes, my lord.
But also the court expressly took account of fairness between the parties, because another reason given, just very short, on page 70, was it was unfair to the respondent that they'd had absolutely no notice of what your arguments were in advance of the appeal hearing.
No, but my lord, the party on the other side, they consented to the application. So they themselves would not have been prejudiced. They themselves indicated that they would have transgressed from the standpoint of filing submissions as well.
Well, they may have agreed to an adjournment, but if the court wasn't going to give an adjournment, it would then be unfair to them. They didn't accept that it would be fair to them to argue the appeal, did they, without any written submissions?
Right, my lord, but we are, again, when we get to the issue of proportionality, with respect to taking the nuclear approach, my lord, we are saying that, and the learning is clear, they said that should be an option of last resort. There would have been other options that the court could have taken into consideration relative to treating with the matter, my lord. And the issue really and truly is whether they dealt with all of the matters under the respect to the overriding objectives, with respect to making a decision that is proportionate and that is in the interest of justice. So it is not.
Well, can I ask you what you say the test is for this court on an appeal to interfere with the exercise of discretion by the Court of Appeal?
But
what test do we apply?
The test to apply is whether the Court of Appeal took into consideration the matters and the overriding objectives as determined by Part 1.1 and 1.2. And if they did not take into consideration, or did not in their deliberation take that into consideration, as opposed to one item or two items, and the response was not proportionate, then the Privy Council or the board will have the latitude to be able to interfere with that particular exercise of discretion. So while, and the learning say that the court is not the only check on the Court of Appeal's ability to exercise its discretion or to manage the affairs, is the issue of it applying the overriding objectives. And our position is that the court, in coming to its decision, did not address itself fully to the overriding objectives. And when we look at the overriding objectives, my lord, the court had an obligation to, one, treat the aspect of dealing with the matter justly, i.e., a person is going to be deprived of their constitutional right to access to the court. They had to consider that. They had to deal with the issue of proportionality, the importance of the case. No, the court did not get into any aspect that dealt with the issue of the importance of the case, the complexity of the issue, the financial position of the parties, the amount of money involved. all of those matters were not dealt with. And if those matters are itemized in 1.1 and 1.2 are not dealt with, my lord, then the board has the prerogative to be able to interfere with the decision. Not necessarily you agree or don't agree. You can't. The court may not have the prerogative in that sense. Yes, my lord.
Mr. Blaze, you seem to be suggesting that there's an onus on the court when applying the overriding objective to work through the factors listed there as a checklist. But surely the court doesn't have to do that in every case. It's sufficient for the court being aware of the overriding objective to focus on what it regards as the key point, bearing on how it should exercise its discretion in line with the overriding objective.
Yes, but my lord, if the court is to execute what is termed of that nuclear option of basically depriving a person of its rights, there must be a detailed examination of those requirements, because ultimately overriding objective requires that the case and the matters be dealt with justly. And the court itself has indicated that there are only exceptional circumstances that would warrant the dismissal of a case. So if that is to be justified, then there must be a detailed examination of the requirements listed in the overriding objective in order to be able to exercise such a nuclear option.
Yes, thank you.
So, my lord, yes. So, see submission. So when we look at the judgment of the court, even in its judgment at page MS 73, made no mention of any consideration outside of the fact that you filed it late and we're dismissing it. And we are saying in doing that, the court did not pay attention or did not give enough effect, especially such a nuclear option, to the overriding objectives. The court therefore would have erred, and the board therefore would be in the position to be able to treat with the particular decision of the Court of Appeal in those circumstances. So, my lord, the submissions are as they have indicated: one, with respect to the absence of the sanction, and two, with respect to the issue of the court not having complied or complied in any substantial way, especially for a nuclear option such as this, in paying tribute or attending to the issue of the overriding objectives, and having not done that, as articulated in the case of Summers, then the board would have the prerogative to be able to interfere with the decision of the Court of Appeal in those circumstances. Anything additional? And my lord, also deal with the issue of the alternative that was available. So there would have been two practice directions that dealt with the issue of skeleton arguments, my lord. One would have been issued by the Chief Justice Clinton Bernard in 1987, copy of which I've provided, in which the additional remedy of cost against the attorney was provided, and as well the practice direction issued by the Honorable Chief Justice, then Chief Justice Michael de Labastide in 1996, is when another option or another remedy available for the non-compliance, with respect, non-compliance being the matter being removed from the list of appeals to be heard. So our submissions as well, my lord, is that there were alternatives available to the court, other sanctions available to the court to be used for matters of this nature. And we're saying we're dealing with a situation in this particular case, my lord, where there was no transgression before. There was full compliance before in moving forward with respect to the issue of the processing of the appeal. And that the response was not proportionate with respect to the issue of this particular case. And the court has the obligation to be able to look at especially on the issue of proportionality, the issue of the conduct of the party in this particular case. It's not, yes, my lord. My lord, you are muted. Your mute is still on, my lord.
Just two questions. On the 1996 or 7 practice direction, when it says that the appeal would not be listed, does that mean in practice that was it? It would never be listed? Was it a temporary
No, my lord.
status?
No, that's not what it means, my lord.
Okay. And the second question is this. In the procedure before the Court of Appeal, how much emphasis is there generally on written submissions as opposed to oral submissions? The impressions from the judgments we have are there's only a limited room given for oral submissions to supplement written submissions. Is that correct?
My lord, and that, according to the rules, would have been in place from November 2018. In 2017, when this matter was done, my lord, the rules require skeleton arguments.
Okay, court and skeleton arguments. But was the practice only to allow limited oral advocacy beyond what was in the skeleton argument?
No, my lord. If you look at the transcript, my lord, the court would have allocated the day, as they said in their transcript. They would have allocated the day for the hearing of the matter.
Right.
Yes. So on the issue of there being alternatives, my lord, it was not the only option. And from a proportionate response, my lord, there were other alternatives, and it was not the last resort available to the court relative to the issue of treating with this particular sanction in this particular case. Again, addressing the issue of proportionality as the court is required to do under part 1.1 and 1.2 of the civil proceeding rules. So, my lord, unless, my lords, my lord, unless I could be of any further assistance, my lord, those are my submissions.
Thank you. I don't think there are any further questions for you at this point. Oh, Lord Leggett. Lord Leggett has a question.
One relevant factor, Mr. Blaze, the court might have considered in deciding what was proportionate is whether there was any remotely reasonable explanation offered for the complete lack of compliance with the court's direction. And it doesn't appear from the transcript that there was anything better offered in the way of explanation than you're basically saying that you'd forgotten about the case. Is that right?
Well, it wasn't said that it was forgotten, my lord. All right, that
well,
was
what's
not
the explanation then for your complete failure to produce any written skeleton argument for the hearing?
My lord, again, my lord, we had indicated that there was an administrative blunder with respect to the issue of the recording of the directions. That is what was indicated in passing, my lord. And that in the letter where we are applying for the where we sent the letter indicating of our intent.
The letter was on the morning of the hearing, wasn't it?
Correct, my lord. In that we had spoken to the other side and there was an agreement. There was agreement between the parties. So there's no objection from the other side. There was no prejudice to the parties. A short adjournment would have been sufficient to treat with it, even if, my lord, there would have been a sanction with respect to the issue of cost, which would have been more proportionate in the circumstance, my lord.
Thank you.
Thank you, Mr. Blaze. We'll now turn to the Philip appeal and we'll hear Mr. Remner now.
Thank you, my lords. Yes, my lords, firstly, I would like to refer to the order which is the subject of this appeal, and that is the order of the 5th day of April 2017. And my lords would see at paragraph 2 of that order, which is electronic bundle page 025. My lords will see paragraph 2, the appeal is dismissed with no orders as to cause. Now, the use of the word dismiss seemed to have created some confusion. And in submissions made on behalf of the respondent seems to suggest that dismiss, the use of the word dismiss, is that the appeal was dealt with on its merits. I wish to say categorically, my lords, that that indeed is not the case. And this issue was clarified before the Court of Appeal itself, albeit a different panel, at the hearing for conditional leave. And my lords would see that that transcript is before my lords, more specifically electronic bundle number 40. It's a transcript of the 8th of May 2017. And my lords would see at paragraph at page 40, lines 20 to 25, more specifically 20, Justice of Appeal Smith is saying the merits of this matter were never dealt with, to which the Respondents' Counsel agreed. Justice of Appeal Smith is saying it was an abuse of process and then subsequently an application to extend time for the filing of the submissions. So, firstly, we are saying that two things, that what the merits were never dealt with, firstly, but secondly, the Court of Appeal seemed to suggest that the source of the court's power to strike out the appeal was based on an abuse of process and not the imposition of any sanction in accordance with the rules. Further support for this can be found if we go at page 42. And at page 42, electronic bundle 42, I raise specifically the distinction between the words dismissed as opposed to struck out at lines 17 to 21. And Justice of Appeal Jamada responded, no, they dismissed the appeal. There is no doubt about that. And then he goes on to say at line 31, They didn't deal with the merits. They simply said from now on, if you don't file your written submissions within the time frame set for case management, your substantive appeal can be dismissed for that reason. So we are saying there's no doubt, there's no ambiguity as to what the Court of Appeal did. They dismissed the appeal. It was purely procedural in nature. And if there's any doubt about that, we look again to the amended CPR, Legal Notice 159 of 2018, and that is electronic bundle page 378, where the CPR Part 64.95 has been amended. And what it essentially says is if you don't, now they've set a timeline for the filing of the submissions, for your submissions. If you don't comply with that timeline, your appeal is dismissed, and the word dismiss is used. So it would appear that the Court of Appeal has been using the word dismiss with the word struck out interchangeably. And it is our respectful submission, my lords, that what in effect took place on the 5th of April at the hearing of this appeal is the appeal was struck out, notwithstanding that the words dismiss were used. While I am on that legal notice, Lord Lloyd Jones had asked a question to Mr. Blaze as to whether the rules have now been amended, in that the rules now provide timelines for the filing of the submissions. I just want to point out that it has only been amended to provide timelines in respect of procedural appeals. That is the effect of the amended 64.95. So in respect of substantive appeals, there's still directions are still given at a causeless hearing by the judge for the filing of submissions. So it is clear, and it is our the manner we have
just to clarify the point, Mr. Ramnanan, these are both substantive appeals, are they?
Yes, these are substantive appeals.
Thank you.
But just as a point of clarification, I wanted to draw to my Lord's attention that that amendment only affects procedural appeals.
So what governs substantive appeals?
Substantive appeals here, timelines for submissions are still fixed by the causeless judge, as was done in these two appeals before my lords.
Thank you.
Yeah. So, my lord, and that would of course affect my submission on 6413. As my lord would see, I have accepted that 6413 has no application because 6413 deals with the situation where the rules are fixed by the relevant rules, which is not the case in this appeal. So the angle we have taken in dealing with this, Lord Legard.
I'm not sure that can be right, Mr. Ramnanan, because doesn't 64 refer to directions by or under a rule? And there can be no doubt the directions are given under a rule, even if it's only the rule which gives general case management powers to give directions.
Well, 13C. Just bear with me, my lord, on this. It says 6413C, any party of the appeal fails to serve a skeleton argument with the time limits specified by or under the relevant rule. And by or under the relevant rule means, in our respectful view, that the rule itself must create, must specify, the rule itself must specify the timelines, as was done in the amended 6495.
Well, that can't be right. Surely
Yes.
then it would just say specified by the rule. But it's envisaging a second possibility, which is under a rule, which is obviously different. And that's
Well,
what must be when the rule gives you power to make directions rather than specifying, gives you power to set a time limit rather than specifying the time limit itself. So
very
here
well.
we're dealing with time limits specified under a rule.
Very well. And if that is the position, that the board wishes to take, then I would entirely accept that position, because that would make, in my respectful view, that would make our submissions more forceful. So it is clear from in our respectful submission, the Court of Appeal, what it did, what was its power to strike out? What power was it exercising? It dismissed the appeal, it would appear, on the basis of an abuse of process and not on the basis of any sanction. And I will come to that when I move to 26.6. I would say, however, that it was not entitled in the facts of this case to dismiss the appeal as an abuse of process, my lords. And my lords would see that I have referred to Grovet and Doctor, and in which Lord Wolf made reference to Lord Griffiths. And what is suggested and what is envisaged is that when you had this comprehensive body of rules, which came into force as the CPR, you would have less reliance on inherent jurisdiction and abuse of process and so on, because you would now deal with the matter under case management as obtained under the rules. And that and you see also Lord Wolf had been advocating the use of unless orders as a means of getting the matter and moving along and avoiding delays in the civil litigation process. So now if we look further down in the said judgment at electronic bundle page 189, paragraphs F to H, the abuse of process is explained in some detail there. And what it says is where there is a situation that the party against whom the proceedings is brought is entitled to where there is the situation where there is delay, the party against whom the proceedings is brought is entitled to apply to have the action struck out. And if justice so requires, the courts will strike out the action. So for abuse of process to apply, the respondent to this appeal has to apply to strike out the appeal. What we had in this case is the Court of Appeal acting on its own motion to strike out. So that is the first point. Secondly, the abuse of process doctrine was summarized as follows: to commence and to continue litigation which you have no intention to bring to conclusion can amount to an abuse of process. And we are saying on the facts of this appeal, there can be no doubt that the appellant had every intention of pursuing this appeal, albeit that his submissions was filed late. The appeal was set to go on the 5th. The appellant had no objections with that. The appellant was ready to proceed, and it was the respondent who sought an adjournment in this matter. So we say that even if abuse of process is what was relied on by the court, it is inconsistent. The decision taken by the Court of Appeal is inconsistent with the abuse of process doctrine and the court's power to strike out on abuse of process. I move now, my lords, to part 26.6. My learned counsel for the respondent in his submissions seems to suggest that the rule says in 26.6 that wherever practicable, you must specify the consequences of the breach. And the respondent focuses on the part which says wherever practicable, and suggests that it is not practicable in every case and in every case management direction to specify sanction. And we respectfully disagree. As it relates to this appeal, the problem that was affecting the court, as Justice Mendonça said, is that there was late filing of submissions had become pervasive, and therefore it was open to the court to give its direction for submission and specify the sanction. And what that sanction would be in response to a question Lord Briggs asked to Mr. Blaze, what that sanction would be a matter for the court. But it is done even up at this time on several occasions. The sanctions are either specified by the rules themselves, such as in witness statements and list of documents, or the court gives a sanction. For example, the court could have said failure to file your submissions by the date, by the dates given will the appeal will be struck out. Those sort of directions are given all the time. And what you have to do in order to not have to apply for relief from sanction is, if you cannot make the deadline, you apply before the deadline expires for an extension of time. And once you apply for an extension of time, then you meet the test with the lower threshold, which is the part 26(1) factors, but without the threshold factors of promptitude and so on. So you have an easier test to surmount if you do that. So we do not accept the respondent's position that to do so would be onerous at all. But even apart from that, if for the Court of Appeal to have applied 26.6, because your lordships have indicated leave was granted on the basis of 26.6 alone, it was narrowed to that point. I don't know about the other appeal, but in this appeal, that was certainly the case, that it was limited to whether or not the Court of Appeal complied with 26.6. We say the answer to that must be in the negative, because firstly, there was no express sanction under the case management directions given, and that is not in dispute. So the only way 26.6 could have been complied with is if you can read into those directions an implied sanction. And we say that that was certainly not what was done. And the reason why we say that is because Justice Mendonça, who delivered the ruling on behalf of the Court of Appeal, dealt with the application using the principles in Roland James and the Attorney General, which is before my lordships in the bundle of authorities. It's at tab 10 in the bundle of authorities, and that was EB page 261. And Roland James is the leading authority in this jurisdiction from the Court of Appeal that deals with extension of time simpliciter. So it's not relief from sanction. It deals with where there's no sanction and you are seeking an extension of time. That is what this judgment deals with. How do you treat with that? You use the Part 26(7) factors, but without the threshold requirements and so on. In other words, the judges have more flexibility into accord weight to the different factors and so on. So it's a less stringent test. And the Court of Appeal clearly relied in its analysis of Roland James versus the Attorney General. And therefore, implicit in that, the Court of Appeal accepted that there was no implied sanction, and it was not dealing with a case in which sanctions were involved. The Court of Appeal simply said, no, we are not granting you an extension of time. Now, I will just deal briefly, because my learned friend, learned counsel for the respondent, yes.
I'm so sorry. Before we move away from the authority, you say the Court of Appeal accepted that it wasn't dealing with a case in which there was a sanction, but that it refused to extend time. What was the consequence of refusing to extend time?
The consequence of refusing to extend time, well, firstly, what we have submitted is that in the facts of this case, it ought not to have refused to extend time. And we relied, in support of that, I relied on Lord Dyson in the Karen Matthews case.
Yes, I'm so sorry. I was asking what the effect of the decision in Roland James was. You told us that the court refused to extend time in that case, but it wasn't a sanctions case.
In that case, the court extended the time.
Ah, I'm so sorry. I misheard.
Yes.
All right, thank you. Sorry.
But it just deals with the principles that you have to apply when you seeking an extension of time, as opposed to relief from sanction. Lord Briggs. My Lord is on mute. His mic is muted.
Can you hear?
Yes, I'm hearing you now, my Lord.
You say, therefore, this was not a sanctions case.
Certainly not, and that is accepted by Justice of Appeal Mendonça.
But do you accept that if you were not going to be in time with your skeleton argument, you had to apply for an extension of time if you were to be able to use it?
Yes, I would accept that, my Lord.
So
however, yes.
So what is the consequence if you apply for say you put something in a week before the hearing?
Yes.
You can't just do it. You have to get an extension of time to be able to use it. I think you accept.
Yes. Yes.
So suppose you apply for an extension of time to use it and are refused. What then happens to your appeal?
Well, firstly, our submission is that we ought, on the facts of this case, we ought not to have been refused.
I understand, but suppose you are refused, what is the legal consequence of that refusal in terms of the further prosecution of your appeal?
If the legal consequence of that, if you are refused, is that you have no submissions before the court.
So you would be in the same position as was Mr. Crick in the Crick and Brown case?
Yes,
even though, as I understand it, even though you had lodged your submissions, your skeleton argument, you would be in the same position as Mr. Crick, because if you didn't lodge them within time and did not get an extension of time, you accept that means that you would not be able to use them at the hearing.
Yes, notwithstanding that they are already before the court since 3 months, 2 months before the hearing. Yes, that would be
concerned with that. I'm not asking you about the merits of the refusal to extend time.
Yeah.
I'm asking you about the legal consequence consequences.
Yes, I agree. I would accept that position. Yes, I would
accept you that you can have a situation where
I'm not hearing.
I'm afraid the line's breaking up
direction
again.
does not contain a sanction. Direction in time, you must ask.
Could I perhaps
use the telephone service, but it hasn't worked.
Could I perhaps just follow up from what Lord Briggs was saying while he tries to make contact with us again? I think in the submission you've made, you accept there's a difference between cases where there is a sanction included by a direction or a rule, and other cases where the court issues directions. There will be consequences if those directions are not complied with, but that does not qualify as a sanctions case. In other words, there are some cases where a sanction is specified and other cases where a sanction may not be specified, but there will still be consequences if there's a failure to comply with a rule or a direction. Have I understood correctly that there are these two sorts of cases?
Well, there would be consequences if you applied for an extension of time and you were refused that extension.
Yes, even where it's not a case where the direction itself specified a sanction.
Right, even where it doesn't specify a sanction, that is correct.
So
Yes.
what I wanted to your assistance on then is why in our case we're talking about sanctions as understood in the rules. Why aren't there just directions issued by the court which a party fails to comply with, where certain consequences flow from non-compliance, which those consequences presumably being determined by the court deciding in its discretion and applying the overriding objective how the case should be handled in light of the failure to comply with the direction?
Well, for two reasons. Firstly, in respect and the particular facts of this case, where the appellant did not comply with the timeline for filing its submissions, you would ordinarily have to file an application for extension of time. However, what is noteworthy in this case is that the defendant waived the breach. In other words, the defendant, by its conduct and by its express actions, waived insistence on the need for the application of an extension of time. And that is why we refer to what ought to have happened is what Lord Dyson has set out in Karen Matthews, where he said, if no one does anything, or there's waiver of the breach, then the application for extension should ordinarily be allowed, because no one has taken any step. Either no one has taken any step, the defendant or the court, or the defendant has waived the breach by its conduct.
But it's not entirely in the gift of the defendant, is it? And the court has set the directions both to ensure that there's a fair disposal as between these parties, but also to ensure orderly progression of business before the court, not just for these parties, but for others. Whereas the consequence of what you seem to be urging is that the court could just have lost a day dedicated already to the hearing of this appeal in its list because your side had not complied with the timetable which was put in place to ensure that the hearing could be effective on that day.
Well, in response to that, my lord, firstly, we are saying if the defendant, I agree that case management cannot be in the hands of the parties alone. The court must have the power to, particularly when considering the overriding objective and the administration of justice in particular, it must have some residual power at least to deal with matters like that. But we are saying that if the respondent waives my breach, the appellant's breach, then the burden is now on the respondent to be ready for the appeal. Because the respondent is saying, we are not taking issue with your breach. Well, then the respondent has to get itself ready for the appeal. If the respondent is not ready for the appeal, then you cannot come back, raise the breach which you have already waived and said, it's our fault that you were not able to comply when your own reasons for not complying was for reasons other than our late filing. So my lords would see both in the letter to the Court of Appeal and in oral submissions before the Court of Appeal, the states, the respondent's reason for not being ready and not filing its submissions was not solely attributed to the defendant's, the appellant's late filing. The state, the respondent indicated that they had some internal issues, counsel had left, and they were having some problems appointing new counsel and so on in the matter. And they were essentially seeking an adjournment for reasons other than the appellant's late filing. So much so that they sought our consent to their application for an adjournment. So the short answer to that is that yes, the court reserves a power in the interest of administration of justice, and parties cannot by agreement just simply ignore the court's timetable. However, in a case where there has been a breach, a waiver, the respondent obligation was to be ready for the appeal, and they ought to have sought indulgence of the court if they were not ready.
Yes, thank you.
Yes. So I don't think in terms of any implied sanction, I think our position is clear that there was none, and the Court of Appeal did not consider that there was. But just for completeness, I would add that in response to question posed by Lord Sales to Mr. Blaze, that it is my respectful view that notwithstanding the facts in the Karen Matthews case dealt with a part 13.3 application, the reasoning in general deals with the notion of an implied sanction, and Lord Dyson made several references to rules, other rules which carry the sanction as part of the express wording of the rule itself, and therefore 13.3 he found did not have such a wording, and that would have been the basis. He of course went on to support that finding by comparison, for example, of the 13.3 test and the relief from sanction test, and to show that it would have created a conflict because of the less stringent test under part 13.3 in terms of delay, as opposed to the promptitude test under part 26.7. And therefore, in respect of the authorities relied on by counsel for the respondent, that would be firstly the Wolf Rock Authority, which is at tab 14. We say that those principles are not applicable in the context of our CPR. What the judge was saying at paragraph 35 is it is impossible to believe that the orders of the 25th of June and 23rd July was implying that evidence should be filed and served by certain dates, was implying that it was that if it was not filed, that evidence could be admitted without further ado. We have accepted it cannot be. You have to file an application, but an application for extension of time as opposed to relief from sanction. And again, in the other authority relied by my learned friend, and that would be the MIDI sales, which is at electronic bundle 365. We do not agree with the proposition at paragraph 50 and the distinction sought to be drawn by the honorable judge, specifically in relation to the judge's evaluation and or finding that in relation to 26.7, our 26.7, which is relief from sanction, the sanction need not be imposed by the rule itself. In this case, the sanction was not imposed by the rule itself. The judgment for default was taken up after. And we think that the position set out by Lord Dyson is more opposite and applicable, because Lord Dyson quite correctly set out that when one does not file a defense on time, what he does, there's no sanction that kicks in because of that. What he does is he makes himself susceptible to judgment being entered. But the sanction does not automatically kick in as a breach of the rules. And we say that that is a position that we would advance, that Lord Dyson's position is more appropriate. But I also want to submit to the court that assuming that it was possible to imply a sanction, let us assume you could imply a sanction, then what would that sanction be? The question has to be asked. The only sanction that could possibly be implied from the failure to file submissions is that you would not be able to rely on your submissions. It certainly cannot be implied that your appeal will be dismissed necessarily, or that your appeal will be struck out. And in support of that, I would take my lords, because this issue has been dealt with by the Court of Appeal. So I would take my lords to the transcript on EB electronic bundle, page 139, page 246, tab 8, lines 28 to 31. And firstly, lines 32 to 38 in the first instance. And my lords would see Justice of Appeal Kangaloo was clearly drawing a distinction between the failure to file evidence and the failure to file submissions. And then he goes on at line 45 to say, well, what is the consequence? Basically, he's saying, what's the consequence of not filing submissions? If you want the judge to go and research all the law on their own without the assistance of counsel, and that is why Justice of Appeal Kangaloo draw a distinction between evidence and submissions, because submissions are primarily to assist the court in dealing with whatever application is before it, and that was accepted by the respondents. If my lords would look at the respondent's objection, notice of objection, paragraph 20 at electronic bundle, page 139, the respondents accept that the effect that the Court of Appeal would have been entitled to proceed and deal with the matter without the benefit of the submissions and without the benefit of the assistance of the parties. Although they were not bound to do so, is what the respondent is saying. But they accept at least that that would have been an option to the court. And the point I'm making is that failure to file submissions is in a different category from failure to file written evidence. And there's a distinction. And
could I ask you this
Yes.
about what you say should happen if you don't file your written submissions in time?
yes,
I think you accept that a consequence may be if an extension of time is not granted, that you can't make submissions. You say that submissions are there to assist the court, but one might think that submissions are primarily there for a party to advance their case.
yes,
And so isn't the effect where you're not allowed to advance submissions because of your own procedural defaults,
yes.
that you are simply before the court and in practice unable to advance your case? I cannot myself see that the court is then under an obligation to research for itself what arguments you might have presented if you hadn't disabled yourself from doing it.
Okay, well, to assist my lords, I would just put a situation to my lords, if my lords would allow me. Suppose, for example, a counsel does in fact file submissions, but he is so incompetent that his submissions provide no assistance to the court whatsoever. But my lords, their lordships are seized of knowledge of the law and can on their own see that there are some grounds in his appeal, even though his submissions provides no assistance. What is the court to do in such a case? The court would not dismiss, I do not think for myself that the court would dismiss his appeal, notwithstanding his submissions provides no assistance. And that is similar to our case, to this case, where, or to a case where you are debarred from filing submissions, but there's merit in your case on which their lords sees of their own knowledge of the law and so on can see that there are some merits in the case. The point I'm making, my lord, is that you cannot have uncertainty in application of the rules, and to lead a party to speculate what might happen and what might be the consequence of a failure to comply is not what is envisaged by the rules. Our rules, our CPR is quite simple. It's easy to understand and it leads to certainty. There are two things. There are two things that can happen. Is either when an order is given, a sanction is specified. But there is no room for implying anything because it says what must happen if you do not give a sanction. So Rule 26.3 of the CPR says if no sanction, it deals with cases where no sanction is specified by the court. If no sanction is specified and there's a breach, then you must apply to the court for an unless order. So there's certainty and parties must know and be fully aware of what the potential consequences of their failure will be. And that is the combination of Rule 26.6 and 26.3 provides for that. So there can only be two situations. Either there's a sanction or there's no sanction. If there's a sanction, 26.6. If there's no sanction, 26.3. And the purpose of this was to let parties know at all times what is going to be the consequence of your breach. And that is why it is made mandatory in 26.6 that the court must specify the consequences wherever practicable. Lord Sales.
Yes, could I ask in relation to that? I rather wonder whether 26.3 read with 26.6
Yes.
does convey the idea that a sanction is something specifically written into the order or direction, such as an unless order, unless you comply with a particular direction by a certain date, your case will be struck out. That would clearly be a sanction.
Yes.
But going back again to the distinction between cases which involve a sanction, as that term is used in the CPR, and those which don't involve a sanction, isn't the position clear that in cases which don't involve a sanction, but where you have failed to comply with, for instance, a procedural direction, you're then just left with the court applying its discretion as to what should happen in light of that failure, applying its discretion in line with the overriding objection, overriding objective, forgive me. So that it's not that there are no consequences at all. There may be consequences and they might be very severe, but they haven't been specified in the order, and they will be imposed as a result of the court exercising its discretion at the time which falls for it to do so in light of the overriding objective.
Yes, I accept that, but as I indicated, Roland James, the Court of Appeal has set out how that exercise is to be done. And great emphasis, it's a different test, it's a less stringent test, and great emphasis are placed on the prejudice to the parties under that test. So, for example, in Roland James itself, the appellant stood to have his whole defense. He would not have had a defense if he did not succeed under 26.1. So therefore, we are saying, yes, there would be some consequence, but in considering 26.1 factors in an extension of time, as opposed to a relief from sanction, you have to give due regard to what are the likely effects and consequences, and that must be given substantial weight.
Yes, thank you.
Yes. So, and the need, and even, and my learned friend also rely on the case of Kalili versus Bennett, which is at tab 12. And if I just take my lord quickly.
What page is that, please, Mr. Ramno?
If my lords go to page 293, electronic bundle 293. And if my lords would say paragraph 18, that this is a well-known passage which reads as follows. And the law as it applies to this case may therefore be stated thus. But what is important here is it says, delay which involves complete, total, or wholesale disregard, put it how you will, of the rules of court with full awareness of the consequences. And that is the point I want to stress, is capable of amounting to such an abuse. And what we are saying here, what the rules have tried to achieve is certainty, and that the parties must be able to know specifically what are the consequences of the breach. My lords, insofar as my learned friend has also relied on the judgment from the High Court Trinidad, the Justice Rampasad, and the PSA, that is EB 349. I will not get into it much. Safe to say that we accept what Justice Rampasad and the position he took when treating with his analysis of Karen Matthews. We are not, our position is not inconsistent with that. The difference is that Justice Rampasad there was dealing with a case where there was an application for default already. So Justice Rampasad was saying, there's already an application for default. You cannot just file a defense without an application for extension and try to rely on Karen Matthews, because the learning in Karen Matthews and from Lord Dyson at paragraph 16 is if the claimant does nothing, or if he takes no step, does nothing, or a party waives the breach, then you can put in your application will be granted. So it is not automatic. So we do not dispute what Justice Rampasad is saying in that judgment. But we are saying, of course, as I indicated earlier, in this case, there's waiver of the breach by the conduct, and we've put in three authorities of very similar circumstances as it relates to conduct, and that would be the Treasure Island and Audubon Holdings Limited at tab 4, the St. Kitts Development and Gulfview Limited. They are all in the written submissions, my lord, so I don't propose to delve into them, save and except that they support the proposition that where the defendant or another party has conducted themselves in such a manner that they would not oppose the breach, it will be deemed a waiver, and therefore the CPR would not allow technical ambush to take place and to allow a party to come on the morning of the trial or as the morning of the appeal in this case and say we are opposing your application for extension. So,
Mr. Ramnanan, in this case, was there any indication by the respondents that they were not going to oppose an extension of time prior to the morning of the hearing?
yes, my lord. By letter of April, there's a letter, if I can take my lords to it, it's in the supplemental record. Letter from the respondent to the Clerk of Appeals, 3rd of April 2017.
10th of April, did you say?
Yes, EB page 127.
Thank you. Can we just look at that?
Yes, and that would have been a telephone call would have taken place, and this letter would have emanated from the respondent based on a conversation that took place between myself and the respondent. And there was never any issue, as my lords would see, about any position being taken about the appellant's breach.
Yes, thank you.
And of course, none was taken before. At no time before that did the appellant communicate, the respondent communicate with the appellant and say, look, you filed out of time. We are unable to make, we cannot make. I would point out as counsel for the respondent in the Court of Appeal at the leave hearing admitted that they still had their full month. So notwithstanding the appellant's delay, the respondent submissions was due 1 month after. So February, I think the 24th or 28th we filed, the appellant filed. If you take a month from that, it takes them to March 28th. So notwithstanding we filed late, had the respondent still used the 1 month from our filing, they would have still at least have had their submissions in as at the time of the hearing. And in response to a question, Lord Hamblin addressed a question to Mr. Blaze in relation to whether the appeals proceeded by oral hearings only, or whether the oral hearings were merely supplemental to the written submissions. The practice now is that the oral hearings supplement the written submissions. But these are, of course, matters of discretion for the court. There have been instances where submissions have been filed late and the court has asked party, are you ready to proceed orally? As was in this case. If my lords look at the transcript in this case, Justice Mendonça asked the respondent, are you ready to proceed orally? So they have that discretion. it's not a rule of thumb that you must, if you don't file written submissions, you can't proceed. It would be a matter for the Court of Appeal if they feel that it is the type, it's of the nature and complexity and so on that they can't handle by dealing with it orally, they can't do that. And my lords would see that in the transcript that they did ask the respondent, that question was posed to counsel for the respondent, whether they were ready to proceed orally. So I would want to close with just saying that what the Court of Appeal did is exactly what Lord Wolf refused to do in Grover. And if I take my lords to page 185, EB page 185, in Grover versus Dr. Paragraph between G and G, it says to extend the principle, referring to the principle in Burkett, to extend the principle purely to punish the plaintiff in the illusory hope of transforming the habits of the other plaintiff solicitors would, in my view, be an unjustified way of attacking a very intractable problem. And that is precisely what has happened here. The Court of Appeal had available to it a comprehensive body of rules that allowed and permitted to deal with this problem that it thought was becoming pervasive and so on, the late filing of submissions. It could have applied 26.6 to apply a sanction when it issued directions. Alternatively, it could have applied 64.13 and say, look, if this problem is becoming pervasive, we will now invoke 64.13. So quite irrespective of whether a defendant applies a strikeout or a respondent, we can do it on our own motion if it's a problem. But notwithstanding that, the Court of Appeal took a different approach and said, you know what, we will make examples out of these appellants, the Philip appellant and the Crick appellant. And that is exactly what Lord Wolf declined to do. Instead, you ought to deal with it by invoking the rules that are available. Lord Legat.
Apart from that argument, Ramnanan, isn't the fundamental point here that if the court was going to make an example, there wasn't a reasonable basis for making your clients the loser of the example, because at the very least, the respondents were equally at fault in the situation that had arisen.
That is correct, my lord.
And what was
precisely
unfair, or
yes,
seems to me at the moment, unfair, is the fact that if the court was going to, which it may have been entitled to do, say, well, we need to deal with cases efficiently, and if the parties don't allow us to do that, they must face consequences.
Yes, my lord.
When the respondent was equally at fault, visit the entire consequence on the appellant.
Yes, my lord. And the authorities at tab 4, which I had alluded to earlier, at tabs 4, 5, and 6 addresses the effect of that, and it's all in the written submission. So I have not, I would not go specifically into the authority, but they all deal with the issue of waiver and the conduct of the defendants and so on in those cases. So, my lords, we that under the rules, in summarizing and closing, we say that under the rules, that there was any striking out that has to be done under the rules. And under the rules as they currently are, there was no basis for the striking out. There was no jurisdiction to strike out because the Court of Appeal did not invoke procedures that were available to it. So it's not that, to the extent that the submissions became, late filing of submissions became pervasive, that was in our respectful view self-inflicted, because there were provisions to apply under the CPR to deal with that problem, which was not applied. And we say in all the circumstances of the case, the use of the nuclear option of striking out was without basis in law. Firstly, it was without basis, but even if there was jurisdiction and there was a discretion, it was exercised erroneously and inconsistent with the overriding objective. Unless my lords wish to hear me on anything further, those are my respectful submissions.
Thank you, Mr. Ramnan. I don't think there are any questions for you. We'll adjourn for 5 minutes.
Thank you, my lord.
This is the resumed hearing in Crick and Brown and Philip and the Commissioner of Police. And we'll now hear from Mr. Pennington Benton.
Thank you very much, my lord. Can I just do a sound check?
Yes.
Yes, thank you very much. Can I just start, please, with clarifying one issue about the scope of the appeal? If your lordship can just turn up page 7 of the electronic bundle. That's the joint order granting leave to appeal in both matters, restricting permission to the question of whether the Court of Appeal complied with Rule 26.6. The typo, but that in any event is what the scope of this appeal is about. Can I just then turn up 26.6 and more generally the provisions in which that sits? It's at 86, page 86, please, the bundle. Now, insofar as jurisdiction is, notwithstanding the grant of leave, an issue that needs to be resolved, one can see here at 26.2 the source of the power to strike out a statement of case. I'm working on the basis that that includes a notice of appeal in circumstances where the Court of Appeal can apply these rules, as well as the Supreme Court. And in my submission, one has to read 26.2, which deals with the failure to comply with the rule, practice, direction, or court order. And then the second limb there, 26.21b, abuse of process. One has to then read 26.6, which is further down on electronic page number 88, together. So 26.6 deals with the court's powers in cases of a failure to comply with rules, orders, or directions. So my submission in this case is not really about 64.13. It's about a power. If it's about strikeout at all, it's about a power consequent upon the failure to comply with 26.6 read with 26.2. Now, the reason I raised that is because, again, this ties in, I think, the point Lord Sales took us to at 26.3, which refers to...
Sorry, Mr. Pennington, the whole system went down for a moment there. You were just saying that this case was not about 64.13, but about 26.2.
If it concerns strikeout at all, then it concerns, in my respectful submission, 26.2, which must then be read in light of the requirements of 26.6. So in other words, if a court is going to exercise a power in relation to a failure to comply with rules, orders and directions, i.e. the power that has already been intimated in 26.2, namely including strikeout, then 26.6 applies, so that the board's grant of permission focuses on whether this was complied with. Now, as I had understood the case against me originally, the complaint was, well, look, the Court of Appeal has imposed a sanction, namely it struck out my appeal without telling me in advance. Effectively, it's a fair notice complaint, and the allegation is that the Court of Appeal was required to give advance notice under 26.6. It now appears to be accepted, however, that this is not a sanctions case. In other words, whatever the Court of Appeal did doesn't fall within 26.6 because, as I think has been clarified, no direct sanction applies in the case of somebody who fails to file written submissions. All that happens is, yes, Lord Legate.
Are you accepting, Mr. Bender, that we should deal with the case in the round, notwithstanding what was said in the permission to appeal? So if we could find ourselves to that, as you point out, there'd be nothing really at all to argue about.
Well, unsurprisingly, my lord, that's the position where I would like to say we are, because there is no, in my respectful submission, this is not a sanctions case. All that happened was, having failed to file written submissions, the general provision in 26.1 applied, and as my Lord Sales says, the appellant had to look to the general court discretion under 26.1d, namely to extend or shorten the time for compliance of any rule, practice, direction, order, or direction of the court. So the effect that is complained of, namely the dismissal of the appeal, is not something that flows directly from the failure to file written submissions. Rather, it fails from the failure to apply in time, to extend the time to file written submissions, and then it flows from the fact that the application that was made on the day of the hearing failed. It can't possibly be the case, in my submission, that when the Court of Appeal said you must file your written submissions by X date, it had to go on and say, oh, and by the way, if you don't, and then you don't make an in-time application, and then you make a very late one, and then you don't have good reasons, you might lose, and you might lose your appeal. So, given that that can't possibly be the requirement of 26.6, in my respectful submission, the appeal does fall to be dismissed on the simple basis that 26.6 doesn't apply to it. However, not to spoil any party in that regard, I obviously do have some submissions to make about the general fairness of the case. It's worth just briefly turning up, and I'm obviously mindful of the observations made by my Lord Legate before the break. Can I just briefly turn up the judgment at first instance at page 50 of the bundle? That's 1.5, please. So one can see immediately there that the claims for constitutional relief arise out of an eviction from a property which took place on the 21st of September 2007. The complaint by Mr. Phillip was that the police unconstitutionally assisted in a private eviction, that itself, the eviction itself, was unlawful. However, as we can see from page 16 of the judgment of the bundle, the claim, the separate private law claim, in which Mr. Phillip sought to prove the unlawfulness of the eviction itself, parasitic upon which, of course, is the constitutional claim, was issued in 2008 and then withdrawn. Some 3 years later, in 2013, the constitutional claim is filed, i.e. 5 years and some months after the original eviction back in 2007. And indeed, delay was the first and primary ground upon which the judge at first instance dismissed the claim. he had some very serious reservations about the merits of the claim as well, and whether it was an abusive process. But the primary point was, he said, well, look, this is just too late. Now, I'm not suggesting that the Court of Appeal certainly expressly took into account these points. They didn't. But insofar as the Court of Appeal was looking for a case in which to make the point that delay was too prevalent and becoming too problematic in the cause, someone standing before them in 2017 in respect of an alleged violation of their rights which took place 10 years earlier was pretty much a good case to take. I would also, though, ask your lordships just to turn up, please, the order itself. Bear with me just a moment. Well, actually, I can just deal with this without asking your lordship to turn up the order. It's much easier. I can just deal with the chronology, which I don't think is at all contentious. But the directions were given by the Court of Appeal case list manager on the 8th of July 2016 to file submissions in support of the appellant's appeal by 29th of December 2016. So there's 6 months within which basically to file those submissions. The submissions were not filed until the 24th of February 2017. No application was made at that time to extend time within which to file the submissions. Rather, what was agreed, at least tentatively, I accept with the respondent, was, well, look, let's both apply for an adjournment. And in my respect of submission, what the Court of Appeal was perfectly entitled to be annoyed about was for litigants to simply rock up on the day of a hearing and say, oh, well, we've tied it up between us. We want to knock it off for another day. How does that suit you? To which the Court of Appeal turned around and said, well, not very much, actually, because a day has been assigned for this matter. And the appellant, I accept, bore the brunt of it, but in circumstances where it was their submissions that were so late, and in respect of which no application was being made, I would hopefully differ from my Lord Legate's provisional view that the respondents and the claimants were respondents and the appellants were equally to blame. It is clear from the letter to which you have been referred that the lateness of the appellant's submissions was a significant factor in the reason why the state had not filed their submission. I would, of course, accept, as Mr. Ramnanan says, that that was not the only reason. There were additional problems within the office and so on.
At the hearing, counsel for the respondent applied for an adjournment on the basis not that she'd been prejudiced by the delay in lodging the submissions by the appellant, but on the basis of what had gone on in the office and the fact she'd only had the file on the Monday previous.
Yes, well, the application was made, I think, to be fair, very, very briefly, and certainly those were mentioned, but also those reasons were, as your lordship says, mentioned. But also, if one reads the transcript of the Court of Appeal, their focus, of course, is on the lateness of the submissions, and they do say at page 29 of the electronic bundle, at line 20, Justice of Appeal Mendonça, what has happened today. I'm on page 29 if you're there. What has happened today, because of the short time the state has had to prepare this matter, is that the matter cannot go on today. So why should we extend time for the filing of your submission? So,
but was that entirely fair to the appellant when Ms. Khan had already said, page 28, starting at line 9, apologising to the court that counsel for the state left the department in January. It was only on Monday that she and Ms. Maharaj got the file. And it was a voluminous matter that was too much for them to read. And she sought an adjournment on that basis.
Well,
so was the judge was Justice of Appeal Mendonca being entirely fair when he put it that way at page 29?
Well, in my submission he was, because it's clear from the respondent's letter that one of the reasons was that the submissions had been received on the 24th of February. And of course, I accept that Ms. Khan seems to be saying, well, look, I only got the papers in January, even at the end of January. But if it was a further month after that, that the state would have received the written submissions. Yes, sorry.
But even on the original timetable, the respondent was meant to put in submissions within a month. And it had had 5 weeks. And simply to say that we haven't had time to read the papers yet, let alone prepare anything in writing, it was certainly no better than the appellant, was it?
Well, I think, my lord...
in one view, a good deal worse. At least the appellant was ready to argue the case on the day.
Well, I think, my lord, if one takes the case in the round, my submission is for the reasons I've already said, that the claimant's delay has been far worse. But I do accept that one of the reasons that they turned up and had agreed to an adjournment was that they were also struggling with internal personnel reasons. I accept that. But what none of this can do at the end of the day is to effectively tie the hands of the court in terms of the way it manages its own sets of proceedings, and in particular the fact that there are other litigants waiting in the wings. So another way to look at this, my lord, is to say, well, all right, in this case, as it happens, the appellant perhaps bore the brunt. But in other cases, it will be the respondent. The fact of the matter is, whoever's fault, there will always be one side that comes off worse in circumstances where an appeal is dismissed.
But the court has to deal with the case before it, doesn't it? And where both parties are equally at fault, it's not an answer to say to that litigant, well, it's all right for me to be unfair to you, because in another case, I'm going to be unfair to the opposite party. The court has to be fair to both parties, and to visit the entire consequence on one when they're equally at least at fault simply isn't just, is it?
Well, respectfully, my lord, I wouldn't, unsurprisingly, I wouldn't put it like that. What I'm saying is the court is saying, for whatever reason, maybe both of your faults, but certainly it's the appellant who hasn't applied for permission to rely on their submissions, and therefore there's no submissions before the court. It's your appeal, it's your duty to prosecute it efficiently and effectively. If you don't, it risks being dismissed because there aren't submissions before the court. All I'm saying is if that incidentally happens to affect the appellant more than the respondent, it's not a question of visiting unfairness on one party, it's just a case of making an objective decision on the case. And obviously it's going to affect one party more than the other, isn't it? I mean, suppose this, my lord, suppose the appellant had made a timely application to extend the already generous 6-month period for filing their written submissions. Suppose that application, rather than being made on the day of the hearing, had been made even out of time, but a couple of months before the hearing. It may well have been listed and heard and decided in their favour. Then the appellant could have come to court and said, well, look, here's my submissions. I'm ready. All right, I was late, but they're done. They're there before the court. I've made a timely application and I can press ahead. And in those circumstances, of course, then the respondent would be in difficulty. But that's not the position the appellant put itself in. Why should the appellant be able to simply rock up and say, oh, well, we're both as bad as each other. Can we knock it all on the head, please? my submission, it's just not an appropriate way of conducting a litigation. And the Court of Appeal was right to put its foot down and say, look, enough is enough. However, and having said all of that, I do, of course, and my client, if I can put it like that, accepts, of course, that any changes in legal culture or practice in particular fields need to be made in a way that is fair to everybody. And I have set out in my case why the government certainly does accept that the court does need to proceed carefully and proportionately when summarily dismissing, if I can use a neutral term, people's claims or appeals. And I do accept what is said by both appellants, I think most forcibly by Mr. Blaze, that the court should have regard to the effects of any of its decisions on the litigants and their constitutional right of access to the court. And I have set out in my case what we do propose to the court as a sort of checklist of things that the court should go through, and it includes considering whether an unless order is more appropriate in a particular case, would be a more proportionate way of proceeding, whether advance warning provided by the court of potential summary dismissal of appeals. And I do refer those cases to your lordships, and hope that obviously, no matter what is the result of this appeal, that those points are made clear. But in terms of whether these particular two appeals should succeed, I think, as I've made clear in my case, my primary submission is that this not being a strikeout case, there can be no cause for complaint. The court did not strike out the claim, did not strike out the appeal. Rather, the court simply refused permission to rely on written submissions, which had the effect of the appellant being without submissions, and therefore the appeal was dismissed on its merits, although I accept without going into the merits. In order to make that point good, if I need to do so, can I just ask your lordship, please, to turn up the Court of Appeal reasons? This is in the transcript, start at page 26. I know your lordships will have already read these, so I can be fairly active. The part I wanted to emphasise starts on page 29 at lines 37 onwards. This is a matter we fixed for today. This is talking to the appellant's attorney. You had ample opportunity to meet the deadline on a proper application of the overriding objective. This matter should be dismissed because of the lateness in filing the submissions. We hear these matters on written submissions.
Sorry, forgive me, where
Page 29 of the electronic bundle, and it's line 38 onwards.
Yeah. Yeah.
So there are sort of notes, I accept, of, well, look, if you haven't filed written submissions, you're out. But then, and on the next page at lines 32 and onwards, you know, it's almost taken for granted, said Justice of Appeal Mendonça, that the court would rubber stamp a request to extend time. No proper application is no application before the court, no written application to properly explain the delay, which is a factor that we must take into account. Various reasons are put forward in terms of difficulty of obtaining counsel to deal with the matter, which is then addressed by the judge on page 31 at the top. Well, before we were persuaded by that, you would have required evidence as to what efforts were made. This is the real problem that I was emphasising a moment ago. There was no application, no advanced application before the court. Then, over the page, can I ask you to turn up, actually, please, page 34. And this is the main substance of the decision. This is a feature, the late filing of submissions, that has more than crept into the Court of Appeal in recent time. It's becoming very pervasive, putting us deeper into the hole if we adjourn these matters and allow further time for delivery of submissions. Then at page 19, directions given at the cause list are orders that are meant to be complied with, they are not suggestions. And then at lines 26 and onwards, I'm sure your lordships have read this already, but we have before us today an application to extend time made from the bar table. What we have heard doesn't convince us that there is any good explanation for the failure to file these submissions when they became due. They were filed 2 months later, and then refers to the case of Roland James dealing with the factors one takes into account in a non-sanctions case, which of course this is. So the court then goes on applying the non-sanctions case law to dismiss the very late and unevidenced application to extend time. The effect of that, says the court at page 35, line 1, the effect of that, the refusal to extend the time for the delivery or for the filing of the submissions, seems to us to inevitably lead to a position where the appeal would be dismissed, because it is the practice of the courts in answer to a question put earlier on as to, well, look, how does the court hear these matters? Well, the court tells you how it hears the matters here. It is the practice of these courts, in the interests of time and efficiency, to hear these matters largely on written submissions. We'll obviously hear oral submission primarily to clarify what the written submissions say and to allow counsel the opportunity to expand on any point. But the core approach is that we require full submissions in the hearing of the appeals. So in the circumstances of this matter, i.e. by applying the non-sanctions case law to a late application for extension of time, we will not extend the time and we will dismiss the appeal. Yes, my Lord Legate, thank you.
The problem I have with the Court of Appeal's reasoning is that the situation here was symmetrical. Neither side had complied with the direction. Neither side could rely on written submissions on that basis. So why is it inevitable that you dismiss the appeal? You might equally say, because the respondent hasn't complied with the timetable, the appeal must be allowed. There's just no rationale for choosing one approach rather than the other, given by the Court of Appeal.
Well, in my submission, the defendant has the benefit of a reasoned judgment. It is for the appellant, isn't it, to persuade the appeal court that the judge was wrong, and for the appellant to advance their case. And for the primary mode of advancing that case is that stated by the Court of Appeal, namely to file written submissions. In the absence of doing that, why should the defendant be respondent be? It's not equally balanced, is it? Why should the respondent not lose the benefit of his fully reasoned judgment? It's for the appellant to do the pushing, for the appellant to do the work. And if the appellant doesn't do it, they're out.
Mr. Penningham-Benton, shouldn't the learned Justice of Appeal have gone on, and if we accept what he says about the impact on the state of appeals in the Court of Appeal and so on, if we accept all of that, shouldn't he have gone on to consider the proportionality of the course he was minded to take in the particular circumstances of this case?
Well, thank you, my lord. Can I answer that question in this way by saying it would be preferable for the reasons set out in my case, for the Court of Appeal to do that, to have done it in this case, and to do it in future cases, because it obviates the risk of there being a disproportionate interference with someone's rights of access to the court. However, on the particular facts of this case, in my submission, it doesn't matter because of the long history of inordinate and inexcusable and unexplained delay. A litigant cannot reasonably complain about an interference with their implied right of access to the courts. One cannot simply ignore court orders for months and months and months, fail to apply for an extension of time in time or at all, and then when your particular action is struck out, which was in the first place dismissed on the grounds of delay, say, oh, poor me, breach of my human rights. In my respect submission, I agree with your lordship that the Court of Appeal ideally ought to have gone and done that process. What I'm really saying is I'm running a would have made no difference argument, because in this case, the decision of the Court of Appeal was perfectly justified.
Thank you.
Thank you. Lords, I wonder if it is worth just turning up the decision of Matthews. Yes, sorry, my Lord, Lord Towns.
Sorry, just before we move on, am I right in thinking that Roland James is the decision which lays down the proportionality test in a non-sanctions case? The reasons I raise it is that the Justice of Appeal made specific reference to Roland James. This is at page 34. I may be misremembering. I was just asking for assistance.
Yes, I understand, my Lord. To be honest, I would have to have another look at the case to be able to answer that. Can I? It might be that one of my learned friends could answer that.
It's all right. We can read it for ourselves later on. If you can't answer, let's move on. Thank you.
Not off the top of my head. I'm apologise. Yes, could we just turn up then Matthews, please, my lords? That is in the authorities at tab 7.
Page
235. 235, please.
Thank you.
Thank you. This is a default judgment case. It's a case concerning the failure to file a defence by the period required under the rules. Now, the rules, I think, similar to England and Wales, don't say, well, what is the consequence of? They don't say that if you fail to file a defence, you can't necessarily rely on it. It falls to the other party, the claimant, to say, well, hang on a second, I want default judgment. But there is a obvious adverse consequence from failing to file a defence, which is that it empowers the other side to apply for default judgment. And there is also a power under the rules to apply for an extension of time within which to file a defence. Success in which would obviously prevent the other side from applying for default judgment. So, in very short form, the High Court case applied the general discretionary powers under CPR Part 26.1 to the question of whether an extension of time should be granted to file the defence, and held that it should. The Court of Appeal then overturned that decision, holding that really this was a relief from sanctions case because there was an implied sanction under the rules. And what Lord Dyson says about that is picked up at paragraphs 14, 15, and 16 of the judgment. page 241 of the bundle. First of all, at paragraph 14, a defence can be filed without permission of the court. If the claimant does nothing or waives late service, the defence stands. And then secondly, rules 26.6, this is at paragraph 50 of the judgment, must be read together. 26.7 deals with relief from sanctions in respect of a sanction imposed for a failure to comply with a rule. Now, what Lord Dyson says there, and obviously I accept that this is talking about, well, this decision is made in the context of applications for relief from sanction. And what Lord Dyson says is, well, look, the reference to a sanction being imposed in 26.7 is one being imposed as a direct consequence of the breach of the rule in question. This comes back to a point, I think, touched upon by my Lord Sales earlier. And this is an important one, which is the distinction between a sanction properly so called and bad stuff that happens if you don't comply with rules and you don't get relief. And in my respectful submission, well, what Lord Dyson is saying here at paragraph 16, or five lines up from the bottom, it's straining language to say that a sanction is imposed by the rules in such circumstances. At most, if the defendant fails to file a defence and does not apply for an extension of time, he is at risk of a request that judgment in default be entered. That is not a sanction imposed by the rules. Sanctions imposed by the rules are consequences which the rules themselves explicitly specify and impose. Now, I say that interpretive process and conclusion also impacts upon the meaning and effect of 26.61. 26.61 is extracted in the judgment at 237. And you'll also see there that 26.61 says, where the court makes an order or gives directions, the court must, whenever practicable, also specify the consequences of failure to comply. And which, to be clear, my position is that specify the consequences read in the context of 26.62 and that which follows, namely relief from sanctions 26.7, specify the consequences means specify the sanction. But it also means specify the sanction that is a direct consequence of the breach. So in other words, what 26.61 requires the court to do in my submission when it gives an order is to specify any direct consequences of a penal nature from the failure to comply with that direction. And that flows from Lord Dyson's interpretation of 26.7 and what is a sanction. A sanction is something that applies without more. It is not something that might happen if you fail in an application to extend time. And that is why the court is not required to specify the consequences of a failure to file written submissions, because the only consequence is that the defaulting party has to apply for an extension of time, and only if they lose that application may further adverse consequences follow. So the sanction is too remote, if I can put it another way. In order to fall within 26.61, it really has to be, if you don't do X, Y happens. If you don't file your submissions, you're out. If you don't file your skeleton argument, we won't hear you. You can't call your witness. It doesn't apply, as I think was the point, potentially, unless I've misunderstood, that my Lord Sales was getting at in circumstances where the only result is, well, you have to an extension of time. You may or may not get it, depending on how good your reasons are and how quick you make it. That is the point that was being driven out by my Lord Dyson, albeit for a different purpose. And it is the point that we respectfully are driving at in this case, is that these appeals were not struck out. There was no application of a sanction, certainly none envisaged at the time of making the case management directions. It's simply the consequences of a failure to comply, a further failure to make a timious application, and a further failure to have actually any substantively good reasons for the delay. The result of all that is, well, your appeal fails. Can I check if there's anything else I need to? Is anybody? Sorry.
I was just going to say, Mr. Benton, it isn't the result that your appeal fails, is it? There are the 3 stages to the reason. 3 stages. One, that the appeal be struck out, and you say that doesn't apply here. So second, then you get an extension of time. You say, well, the court was entitled to refuse it. But then there's the 3rd stage. Well, what do we do now?
Yes.
And that's a general discretion, presumably, of the court to do what's just in all the circumstances.
Well, the court has few options when the litigants place it in that position. It either hears the appeal on oral submissions,
yep,
or it hears the appeal on the appellant's written submissions, but not the respondent, or it adjourns. And I think the difficulty, respectfully, that the appellants find themselves in is that they're really saying the court's got to adjourn. Is the only fair thing that can be done. So in other words, if both parties drag their feet, turn up to the court, say, look, we're not ready, the court's got to buckle and say, well, okay, I'll adjourn. I think, respectfully, that can't be right. The court normal process, my Lord Briggs.
Mr. Benton, the touchstone for the requirement to specify what are described in 26.6.1 as consequences, rather than necessarily sanctions, is wherever it's practicable to do so. I wonder if it might be said against you that the rule makers have, in a slightly different context, I'm on page 378, in the amended Rule 64.9.5, thought that in relation to procedural appeals, it is practicable to say that if you don't get your submissions in court within 21 days, then the appeal will be dismissed unless the court extends time for the filing of the submissions. Now, I think it's common ground that that doesn't apply to this appeal. But if it's practicable there to set out that set of consequences, and if the reason why, under the present pressure which the Court of Appeal is laboring under, a late filing of submissions such that they're not able to be used at a hearing will inevitably, as was said in the Court of Appeal, lead to the appeal being dismissed, why isn't it practicable here?
Well, I think first of all, I would say that the formulation adopted, the amendment to the rules, is conditional upon another stage in the process, namely, unless the court extends time. I would respectfully say that, well, what is envisaged in 26.6 must be more concrete than that. I mean, otherwise, the court's simply explaining how the world works to people. I mean, obviously, if you need written submissions and you don't file them, and you don't get an extension of time, I mean, isn't really the amendment to the rules just stating what in reality happens? Anyway, it's not saying, well, look, if you do this, there'll be this sanction. It's just saying, well, this is what happens. I'm not really sure it brings much to the rules, to be quite honest. But in any event, my answer, I think, would be that 26.6 envisages specific sanctions. Because it's within the, it has to be construed within the context of a provision that is dealing with relief from sanctions. And also at 26.3, unless orders. What it's really geared up to say is, look, if you're going to make a serious order about something, you back it up with what bad happens if it's not complied. But the second response I would make to that is these case management directions, appeal directions, the same for trial directions. It's not just one element. There's a whole series of given who needs to file what submissions when and in response and so on. It would not be practicable in my submission to attach a sanction to a whole list of standard case management or trial directions or appeal directions. And if you attach it to this one, why wouldn't you attach it to all the others as well, specifying the consequences of not disclosing a document, and, so on and so forth? It would become unwieldy.
Thank you.
Right, just checking my instructions via the modern means of WhatsApp, and I haven't received anything. So I think that's all I need to say. Thank you very much.
Yes, thank you very much. Mr. Ramnanan. You're muted, I'm afraid, Mr. Ramnanan. We can't hear you.
Yes. Yes, my lord, the learned counsel for the respondent referred to 26.2, Rule 26.2, which deals with sanctions striken out of statement of case, to which he indicated he wasn't entirely sure whether a statement of case include appeals. The definition section of the rules, under the definition section of the rules, statements of case do not include appeals. So they include defenses, replies, counterclaims, and all types of pleadings, but not to appeals.
Where do we find which is the definition section?
2.3, my lord.
Thank you. We can look at that.
Yes, 2.3. Secondly, in relation to the merits of the appeal, which my learned friend raised as an issue, we have addressed that at paragraph 28 of our submission. EB page 164. And in Roland James, the Court of Appeal dealt with the issue of merits in saying, so far as the merits of the defense are concerned, the applicant is not required to establish that he has a good defense, or for that matter, outline the merits of the defense. However, whereas in this case, the defendant has put before the court the proposed defense, and the other side wishes to argue the merits of the defense as influencing the outcome, it may not be appropriate for the court to entertain such an argument unless reasonable notice has been given to the defendant that he intends to so argue. So basically, the Court of Appeal in Roland James is saying you don't consider merits, but if you want to consider merits, you must give the other side opportunity. And in this case, that was far from being done because there was not even an indication that there was going to be objection to begin with. But if my lords consider that merits was an issue that the Court of Appeal was entitled to look at, firstly, the Court of Appeal and their reasons, Justice of Mendonça reason, he clearly did not deal with the issue of the merits of the appeal. That was not a factor that he considered, and there has been no cross appeal on that issue that he was wrong not to do that. But in any event, very briefly, I would just say that I think the respondents, with the greatest of respect, the respondents' assessment on the merits is not on point, because and the judge and the judge, first instance judge, seemed to be of the view that having withdrawn the case in the High Court, the first case, which he failed to establish that the eviction was unlawful, and his constitutional claim was predicated on that eviction being unlawful, and that simply was not the case. The first case had absolutely nothing to do with an unlawful eviction. There was a dispute as to ownership and who was the lessee from the HDC, which is the statutory housing company, or NHA, as it was then called. When he withdrew the claim, he filed the constitutional motion on entirely different consideration. And when he filed the constitutional motion, the considerations were, okay, assuming you are the lessee and that I am a tenant, as you say that I am, then the process you use to evict me, that is to say, without a court order, 1. 2, by coming with a bailiff, when a bailiff has no power under the Bailiff Act to evict anyone, as opposed to executing a levy, and then supported by agents of the state, namely a police officer. The state who participated in an unlawful process. So the motion was based entirely on a different issue. That is, had nothing to do with ownership, which was in the first proceeding. It was simply that the process you used to remove me was unlawful, and that the state participated and overlooked and supervised this process. And of course, the issue of delay, therefore, there was no parallel remedy in respect of that. So there was no abuse of process in that context. What may have arisen is the issue of laches, but of course, that is an issue of evidence and a question of fact, which the court would have had to find, and which the first instance judge would have had to deal with. So as it relates to merit, I think it's not an issue. It was not considered by the court. The conditions under Roland James were not applied, that is to give notice. And secondly, even if it was applied, the Court of Appeal could not say at this stage there was no merit, because to do so would be contrary to the overriding objective. You would have the parties effectively arguing the appeal to determine if there's merit or not. So why not hear the appeal one time? It was only 1 day set aside for the appeal. So that would result in a counterproductive process if merit had to be taken into account. Those are my respectful submissions in reply, unless my lords wish to hear me on anything else.
I don't think there are any further questions. Thank you very much, Mr. Ramnanan. Mr. Blaze, Mr. Pennington-Benton wasn't responding to your submissions, but if there are any matters that you wish to draw to our attention arising out of his submissions, we'll hear you. Mr. Blaze, I don't know if you can hear me. Yes, Mr. Blaze. I'm afraid you're muted at the moment, Mr. Blaze. I'm afraid we can't hear you, Mr. Blaze. I don't know if Mr. Sheck's available.
Mr. Blaze,
Can you hear me now? Hello, is that Mr. Sheck?
Yes, sir. I think that he has disconnected from the
Lost
call.
the sound from Mr. Blaze at the moment.
Yeah, appears he has disconnected from this meeting.
Disconnected altogether. Right.
I'm just sending him another invitation.
Thank you very much. We'll see if we can get, we'll give him a minute or two, see if we can get him back. What we can say is that if Mr. Blaze wishes to make any observations in response to the matters which Mr. Pennington Benton has raised, he can do so in writing within 7 days. I think that concludes the hearing. We're very grateful to all counsel in the case and to those who metaphorically sit behind them for the preparation of the case. We'll now take time to consider our judgment. Thank you very much.